Now we're going to talk about governmental regulations and in particular administrative agencies. Administrative agencies have become more and more important over the course of the 20th century and now into the 21st century because many things that regulate our lives are now determined by administrative agencies. So Congress can create statutes, but often, particularly in technical areas, they will draw out statutes that have broad-based regimes and broad goals, but then they will leave it to an administrative agency to actually work out the details of how those rules might really get drafted and applied. So administrative agencies carry out specific governmental functions. They're delegated by the legislature through enabling acts. So the legislature has to pass a statute that delegates certain authority to an administrative agency. Many of these agencies are part of the executive branch, but some are specifically created to be independent so that they function with some appointees from the executive branch, some from the legislature, and so forth, and so that they are independent of the executive. All of the agencies are required to hold public meetings, and the Federal Information Act requires disclosure of information about what the agency is doing, what its decision-making is, unless that information is exempted by statute, maybe because it's confidential or related to national security or something like that. If you are appearing before an agency to make a claim or to challenge an agency action, you will first go before an administrative law judge, an ALJ, and they adjudicate claims related to the agency in the first instance. And then if you don't like what the ALJ said, you can appeal usually to an appellate body that is within that agency itself. And then you can go from there into a court to challenge the agency action, but you always have to go through the agency first. It's what's called exhausting your administrative remedies. You always have to exhaust your remedies through the administrative agency first, otherwise the court won't even hear your case. Now, the Administrative Procedure Act, which is a federal statute that governs administrative agencies, sets rules regarding the procedures that agencies have to go through when they want to make rules or when they want to adjudicate particular claims. And the APA, the Administrative Procedure Act, governs the process by which agencies develop and issue those regulations. And they're required, for example, to provide notice to all interested parties that they're planning to think about a particular rule. They have to publish a draft of that rule in the Federal Register. They have to provide opportunity for the public to comment on their draft rule and so forth. And usually they can't actually put into effect a rule until they've had a notice and comment period, and usually even after that, there's 30 days before they're effective. Now, if you go before an administrative law judge, those proceedings have relaxed evidentiary standards. They don't function exactly like courts do. They're usually a little bit more freewheeling. They allow you to have kind of a broader back and forth. And as I said earlier, ALJ proceedings are reviewed by internal appeal boards before you go into court. And when they get into court, agency decisions are usually subject to review based on whether the agency decision was arbitrary and capricious. So again, it's a pretty deferential standard. As long as the agency was not acting in an arbitrary and capricious way, courts are supposed to uphold what it is that the agency does. And so the agency ends up having a tremendous amount of power to create rules, at least within those areas that are delegated to them by Congress.